Parliament is limited to enacting laws in respect thereof in consultation with the government.
Absolutely right.
That's how I read it.
But that's what I'm saying too. But they are not, at that moment, the law is not made. They are only saying the contours under which Parliament will enact a law. The contours with respect to instrument of accession are those four items: communications, defense, external affairs, and ancillary, which I showed to your lordship the schedule. When it comes to B2, the contours again of the items in the concurrent list over Parliament may make laws. Again, it doesn't say that law is made. It only delineates the contours. Therefore, I'm going to now distinguish it from D, Malad. That's how I'm trying.
Let's come to D. How would you?
I'm just coming.
Yeah.
Then you come to see the provisions of 1 and of this article shall apply in relation to that state. That's not covered. That's not covered.
Right.
So that's Malad's 1 is integration into India. And Malad's, the other is Article 370. Now come to D. Such of the other provisions of this constitution. Now we are not talking about lists. Now we are not talking about lists. We're talking about preamble. We're talking about 356. We are talking about fundamental rights. Each of those orders require the concurrence of the state. I'll show that to your lordship. Here it is such of the other provisions of this constitution. 371B doesn't talk of any other provisions of this constitution. It talks of the instrument of accession and the concurrent list, the contours of the power. When you come to other provisions of the constitution, these may be made applicable. That's why the order. Now let's read it further. Such of the other provisions of this constitution shall apply in relation to the state, subject to such exceptions and modifications as the president may order set specify, not referred to 371B. There's no order, no question of order there. It's only the contour of the power. Now read. Provided that no such order, that is, no such order relating to D, which means provisions of the Constitution of India to apply to Jammu and Kashmir. No such order which relates to matters specified in the instrument of accession referred to in paragraph 1 of clause shall be issued. Kindly note the word issued. That's the difference between 371B and 371D. Because no orders are issued under 371B.
That's the power to make law.
That's only the contour of the power. Your lordship asked me the difference between the two. I'm just trying to advance an argument with respect to the difference. It's entirely different.
Yes, much.
So, Attorney General, that two constitutional practice is one thing. We are now looking at just the text of the provision. There are two possible constructions of clause D. Constitutional practice may seem to support what Mr. Sibal is saying. One is that D refers to the fact that other provisions of the Constitution may apply such
Other than 1 and 2.
Such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. In other words, if you are making exceptions or modifications, that's one construction. That if the President is making exceptions or modifications, then if it relates to a B1 subject, then you require consultation with the state. If it relates to something other than a B1 subject, you require consultation of concurrence of the state. All right? So it is only where you are making exceptions or modifications in the Constitution that it requires either consultation or concurrence. The other interpretation is that even if you are not making any exception or modification, but you are making some provision of the Constitution applicable to the state of Jammu and Kashmir, you still require either consultation or concurrence, even if you are just bodily lifting it and making it applicable without exception or modification. That's the second construction of D.
That's correct.
Now, the question is really which is a more plausible construction.
I can do that. Actually, if your lordship looks at the 1950 order itself, it will give an indication of what was meant. And just not leave 54.
That's why, Mr. Sibal, the Chief Justice, the constitutional practice does support this view, but there are two plausible constructions which can be made. One is that the entire constitution has been adopted in terms of clause D, what can, if you require modification or changes in the part, that part, then you require a presidential order which shall be issued in consultation, not in consultation, with concurrence of the state.
I appreciate that, but that will render 3 OCOs completely. C will become OCOs. Because
C is-
the provisions of the Constitution.
The C is something different. C dilutes the article itself.
See, Madhur, I am not on anything else. When you see other provisions of the Constitution, except for 1 and the 370, you can't touch 370. But let's move forward, Madhur. I'll be able to show that to your lords.
P is 370 and C is Article 1.
And 1 is Madhur's integration.
Integration.
So that can't be touched. Because part of India can't be touched. 370 can't be touched. All other things can be touched.
It doesn't say, C doesn't say it cannot be touched.
Interpretation.
C doesn't say 370 cannot be touched. In fact, clause 3 makes it very clear it can be touched. It doesn't say it's done.
By now, your lordships have, in fact, Madhur, may I tell your lordship something interesting? Because I looked at the original Constitution of India. Learned friend will show it to your lordship. It was only a marginal note. It's not the heading of 370.
It's a marginal note, absolutely. No doubt about it. It's a marginal note.
It's a marginal note. And your lordships have held in Keshavanam Bharti itself. Can't look at these notes.
No, in the sense that a marginal note doesn't control the meaning of the text.
C and 3, Article 3. It can't. A marginal note can't say it is temporary, therefore I read this in this fashion. Can't be done. Anyway, come to that one. Let me Madhur, show you. It's
Yes,
very
yes,
fascinating.
yes.
But I take a bit of time. Let's kindly come to 370 presidential order.
That 1954 order.
1950.
Let's have a look.
50. Same volumes.
1950 or 54?
No, Madhur, I'm coming to 50, Madhur. Liquid text. Volume 3, PDS page 4 months.
This is what you were reading as 13. No,
No,
something.
that is the 54 order. I'm coming back to 1950 order, which was superseded by the 54 order.
This is where?
This is PDF 4 in the same volume. Madhur. The other was on at 13, this is at 4.
So that's 4. Okay.
Yes.
Are you
Kindly
referring
see.
to CO number 10, Mr. Sibal?
Yes, absolutely. Well, let's kindly see the index of this, 3 pages earlier. Yes. See what has happened here. This will give you the kind of orders that have been passed from time to time. There are, by this time, about 54 orders. These are probably not all the orders either.
Very first page of the volume.
Yes,
The first page of the volume.
that's right.
You're looking at
There's a
the
whole
different
index of all the orders.
orders issued.
Yes. The order may be called the Constitution Application to Jammu Kashmir Order 50, which should come into force for the purposes of subclause B1 of clause 1 of Article 370 of the Constitution. The matters specified in the first schedule to this order, being matters in the union list. This is in consultation. Kindly read the words. In exercise of the power of 370, in consultation with the government of the state. For the purposes of B1 of clause 1 of 370, the matters specified in the first schedule to this order, being matters in the union list, are hereby declared to correspond to matters specified in the instrument of accession, governing the accession of the state of Jammu Kashmir to the Dominion of India as the matter with regard to which the Dominion legislature may make laws for the state, and accordingly the power of Parliament to make laws for that state shall be limited to matters specified, which your lordship said is the limitation. Rightly said. Now come. In addition to the provisions of Article 1 and 370, again, of the Constitution, the only other provisions of the Constitution which shall apply in relation to the state of Jammu and Kashmir shall be those specified in the second schedule to this order, and shall so apply subject to the exceptions and modifications specified in the said schedule, and the modification of that all references to the said provisions shall be construed as reference to the Sadre. This is applicable to D. First schedule deals with entries, and this deals with D, because you're not to apply now the provisions of the Constitution of India. and they are all incorporated in the Constitution of India as applicable to Jammu and Kashmir order. So 356 also comes there, Part 3 comes there, Preamble comes there, Directive Principles of Policy come there, but that's all with concurrence. Therefore, it didn't come at this stage, Mullah. Then you went, Mullah, then now kindly see the first schedule you have seen. These are those very entries that we were talking about. And kindly see the second schedule. It starts, Mullah, at PDF 6, page 17. Just for my lord. PDF 6, page 17. Kindly see exceptions. Article 72(1), provisions of the Constitution applicable. So there was no doubt on this issue, Mullah. Entirety of Part 5. Part 5, 72(1)(c), 72(3), 133, 134. Those are exceptions. Last column is modification. So it's not just a question of application. It's a question of substantive understanding of what 370 is. Even if you want to apply a provision without modification, you need consultation with respect to or concurrence. You can't. There is no third way of doing it. Yeah, that's excluded anyway. I said that we've given the examples. Modifications 54 and 50 shall apply subject to modifications that the reference therein to the elected members of the Houses of Parliament to each elected member of either House of Parliament shall be deemed to include respectively a reference to the representatives of the state in those houses and to each such representative. So you modify 54 and 55. Then if 247 you modify. 246 shall apply subject to the provisions of paragraph 2 of this order, and clauses 2 and 3 of 246 shall not apply. So you can't pass a law.
So what is the effect of clause 2 and 3 of article 246 not applying in relation to the state?
Because the residuary power is with the state.
No, but 246(2) refers to the power of Parliament and the state to enact laws on the concurrent list.
That's fine.
No, but if 2 is not applicable, then neither the state nor the Parliament can enact a law on the concurrent list.
It's because of 1B, Malad. It only tells you the methodology, Malad. That's all. The point is, what my lord is putting to me is, the president can exercise powers under 370, dehors a modification. That's an exercise of plenary power. That's what my lord is putting to me. But Malad, this clearly shows that even that exercise has to be done with concurrence. If it relates to the concurrent list and consultation if it relates to instrument of accession, can't be done any other way. So it's not a matter of practice alone. It's the substantive interpretation of 370. Kindly see the first column, Malad. All the articles apply. Part 9, Part 11, Part 12, Part 15, Part 16, Part 17, Part 19, Part 20, everything applies. But in those parts, there are exceptions and there are modifications. That's set out in the third column. Nobody disputes that. The whole part applies.
Clause 3 of the order seems to suggest that the only provisions of the Indian Constitution which would apply to the state of Jammu and Kashmir are those which are specified in the second schedule, and that too with the modifications which were made.
Absolutely. That's our submission, Madam. And then this is superseded by the 1954 order. For example, Part 3 at this stage was not to apply now. It's not in the second schedule.
Let's go to this now the
54 order.
54 order.
Yeah, that's volume 3 again, page 13. Yes. In exercise of the powers, you also have that? So exercise of the powers conferred by clause 1 of 370, President with the concurrence with the government of the state of Jammu is pleased to make the following order. The order may be called the Constitution application to Jammu and Kashmir order. So, Malad, supposing the entire Constitution was to be made applicable, Malad, it would require concurrence, no? Only some are applicable, some are not yet applicable. You will see that 356 comes later. 356 doesn't come at this stage. That would also require concurrence, and concurrence was taken. So any provision of the Constitution of India which relates to the concurrent list would be made applicable subject to the concurrence of the state government. Consultation and concurrence instrument of accession and concurrent list. And Article 1 and 3 are out of it. So kindly see, Malaj. Clause 2, the provisions of the Constitution which in addition to Article 1 and 370, in addition shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows, the same pattern.
So the exception made here is the entire constitution is adopted subject to the
Yeah.
modification
Yes.
made there.
And-
Unlike the
Other than 1 and
1950,
3, other than 1 and 3.
1 and 3 is already there.
That's right.
By, unlike 1950 order, which had specific articles were made applicable, now the entire constitution.
No, because 356 was not applicable at this.
No, but there would be a clause in this saying 356.
It's part by part, not true, Manoj. Part by, see part 1, no, part 2, part 3, it's part by part, it's not all.
Is 356 specifically excluded
No, at
in
this
this,
stage,
at this stage? It would be excluded at
after
this.
part 5, you have part 9.
Yes, come to page 15, 356 is excluded.
Yes,
So
at
the
this-
entire constitution was made applicable by the 1954 order,
Manoj, it said,
except to the extent of exclusion.
Manoj, it's part 5 is state 11 straight away. There's no question of the entire constitution being included.
Just 1 minute.